I'd like to call this tonight's meeting, June 12th, 2025, Zoning Hearing Board meeting to order. Introducing from my left to right, Zoning Officer Liz Ross, Solicitor Chris Volz, myself, Vice Chair Troy Gump, non-voting member Alan Barney, and Board Member Ted Donald, Stenographer Kathy Landock. At this time, I need a motion to approve the minutes from the April 21st, 2025 meeting.
I make a motion to approve.
I'll second that. All in favor, say aye.
Aye.
Aye. Motion carries 2-0. At this time, I'd like to turn the meeting over to Solicitor Volz.
All right, good evening, everybody. As you recall, last time we were here, Range Resources, the challenger, or the applicant in this case, challenging the validity of the recently enacted oil and gas ordinances, completed their case in chief. Township and other opposition parties moved that it would be a good time to discuss ripeness, standing, and whether they had carried their burden to demonstrate that the ordinance was exclusionary, and some other issues as well. The board asked that the parties submit proposed findings of fact and conclusions of law. We appreciate that they were timely filed. We appreciate the efforts of everybody involved. As a side note, they were all well-written, well-presented, and the board appreciates the professionalism provided to us. Tonight, we're going to let the parties share some argument about why we should rule in their favor one way or another. The main brief for the opposition to the application was filed by the township. So, Ms. Moore, I don't know how you plan to divvy up your time. Would you be leading the argument for this side of the table, or how would you plan to present today?
Yes, thank you, Solicitor Volz. I will be leading the argument, but others at my table may want an opportunity to present their arguments, which would not be as extensive as mine, I would imagine. Are you giving us a specific time period, or are we just given free range to complete an argument?
No, I mean, we've been here it's been such a developed process that we're not going to hold you to 15 minutes or anything like that. We would ask that you be as brief and succinct as possible, but we will give everybody an opportunity to present their arguments on both sides. So the board may interject with some questions as we go along. We may ask for the other side to respond to a question or an answer that you give to our question, but I think the way we outlined it is the way to go. We will let this side of the table go first as the moving parties, and then we will let Range Resources present their argument as well.
Mr. Volz, I understand that you may prefer to handle this a different way. I thought for purposes of expediency that it may make more sense, given that Range's presentation of the evidence that it introduced in support of its challenge is going to be relevant to these other issues, that to avoid duplication of discussion of the issues and the evidence, that it may be more efficient for us to go through Range's presentation of evidence and then allow for the opponents in the township to raise their issues, would allow me to just kind of refer to the issues once. I understand you may prefer to do it another way. I just raise it as an option.
I appreciate that, but I think we'll proceed with letting the moving parties present their case first, their argument first, and then we will allow you to respond. But it was well received, thank you. And with that, Ms. Moore.
Thank you, Solicitor Volz, and good evening, Mr. Volz and members of the board. My name is Gretchen Moore. Then I will grab the microphone.
Doesn't seem to be.
Hello?
Yes.
Okay. Good evening, Solicitor Volz and members of the board. My name is Gretchen Moore. I am the solicitor for the township. Mr. Volz, I would like to reserve the opportunity to respond or for rebuttal, if the board would allow me.
Yeah, we will allow a brief rebuttal, and then we'll, if appropriate, and Ms. Brown has something that she wants to get one more word in, we'll let her do one more after that, but we'll cut it off after that.
Okay, thank you. Range filed a substantive validity challenge to Ordinance Number 9 of 2024, and then tried to bootstrap the challenge to Ordinance Number 5 of 2025. What became clear during these hearings is that Range's case in chief, they brought it not because they had standing, they brought it not because they had ripeness to present a case, they brought this challenge because they did not like the township's ordinance. And not liking the township's ordinance isn't enough when you are challenging a duly enacted ordinance which carries a heavy presumption of constitutionality. A challenger can bring a substantive validity challenge under two circumstances under the MPC. And Range has been very clear that they have brought it under one particular section of the MPC, and that is section 916.1A, which states, a landowner who, on substantive grounds, desires to challenge the validity of an ordinance or map or any provision thereof which prohibits or restricts the use or development of the land in which he has an interest shall submit the challenge. And it goes on from there. It is Range's burden, not the township's burden, to demonstrate that it has standing to bring this case. And it is Range's burden, not the township's, to demonstrate that this case is ripe for you to hear. A precondition to bringing a substantive validity challenge is showing that you are actually prohibited or restricted from doing something on land in which you have an interest in. And that means actually, not hypothetically. Ask yourself as you assess this case, what is Range trying to do on property in which it has an interest in Cecil Township, that is currently prohibited or restricted solely by this ordinance? I think you've already heard during these 3 nights of hearings that the answer is nothing. The bedrocks of litigation are standing, ripeness, harm, and bringing a case that is not moot. You, as a board, do not decide this stuff in a vacuum, and that is for very good reason. It is dangerous, it is inefficient, and it is ineffective to challenge ordinances just because one doesn't like them. As such, these issues, the standing, the ripeness, and the mootness, they are considered threshold issues. A case does not move forward unless you satisfy those issues. Let me talk first about ripeness. Ripeness mandates the presence of an actual controversy, not to decide the matter in vacuo, but only after an ordinance has been applied to a litigant. You're not here to speculate about a controversy. It would be a colossal waste of your time and everybody's time to hold court on hypothetical matters. Yet that is exactly what has happened here. The test for ripeness, 2 prongs. Whether the case is developed such that it is fit for judicial review, and the hardship to the parties if consideration is delayed. Range fails that test. The Pennico case belies Range's claim that ripeness is not something for this board to consider. You may have seen that in their brief. They said, oh, board, you don't need to consider ripeness at this time. That's just for the courts. That's not for you. Well, a case must be ripe at all stages of review. You yourself are sitting in quasi-judicial capacity, and the resolution of this case goes to a court to be heard by a judge. So of course, you must consider ripeness. And the Pennico case, which is a Commonwealth court case, totally belies that statement that ripeness is not for you to decide. In Pennico filed a challenge to the township zoning ordinance under section 916.1A. exactly what Range has done. In that challenge, Penneco was operating a gas production well on the subject property, and it was in the process of trying to convert it into a deep gas production well. That's what it was trying to do. It submitted an application to the EPA. It prepared some plat plans to the municipality. And then the township passed an ordinance. And they passed an ordinance that restricted underground injection wells in all zoning districts. It was completely exclusionary on its face. Then Penneco filed a substantive validity challenge. Now, the zoning hearing board in that case initially dismissed it on ripeness because the theory was, well, if they didn't actually get that EPA permit, then this case would be moot because then they couldn't do it, right? It went up on appeal to the Commonwealth Court, and the Commonwealth Court overturned, okay? But this is an important distinction. They said, well, the challenge is ripe for review because Penneco had prepared and applied for the permits for this particular underground injection well. They had surveyed the property. They had created a plat map. In other words, they were trying to do something. So the case in that particular instance was ripe. They had an actual case or controversy. Range's case could not be farther from those facts. You heard very clear, or sometimes unclear, testimony from all of their witnesses and their counsel. They said they haven't even thought about putting another well pad in Cecil Township. They've done no exploration. You might remember with some of their witnesses, I did a series of questions on, let's talk about all the steps to get to a well pad. There's some exploration, you have to sign up some leases, you have to find the land, you have to apply to regulatory agencies. They did none of that. They haven't even done the exploration to determine if they want to put a well pad in Cecil Township. In fact, as you review the submissions from both parties, you'll see every case cited by Range. There was a party with standing, and the case was ripe, or those issues weren't challenged. And they were either ripe or had standing because of something active that an entity was trying to do, right? So I would encourage you, as you go through the submissions after these arguments tonight, to really read all of those cases, not just the sound bites, but read the cases and look at the standing and the basis for why each of those cases was brought. I'm just going to read in particular from one of the cases that they cited. This is a PA Supreme Court case. It's the Pittsburgh Entertainment case, and the PA Supreme Court said some things about ripeness in a case where they were challenging a zoning ordinance. Now, they cited this case for a footnote that made a general statement that really isn't even applicable, and it talks about facial challenges, which I will get to in a little bit. But this case itself actually kicked the case on ripeness. And in that case, the Pennsylvania Supreme Court said, we have applied the ripeness doctrine in this particular context, declining to address claims challenging the constitutionality or validity of a zoning ordinance that has not been enforced or applied. Our rulings in this regard have been premised on policies of sound jurisprudence, namely that the courts should not give answers to academic questions or render advisory opinions or make decisions based on assertions as to hypothetical events that might occur in the future. In this particular case, the Supreme Court said in count 1, PEDP, which was the party who appealed, claims the ordinance constitutes unconstitutional spot zoning or special legislation because it represents an arbitrary exercise of power insofar as the rezoning from C3 to 10A residential prevents the property's use for gaming and its development as a licensed facility under the Gaming Act. The ordinance has not, however, been applied against the property in this regard, and thus far, PEDP only anticipates the ordinance's application to hinder this use. Accordingly, we hold that count 1 is not ripe for adjudication. If Range has no plans to erect a well pad in Cecil Township, which they've already stated they do not, there is nothing for you to decide, period. And the inquiry ends right there. I would like to address the issue of facial challenges because Range raised that in their submissions. And I would ask you please not to bite on this soundbite argument they presented to you about facial challenges. Facial challenges are challenges where you're reading the ordinance, and on the very face of the ordinance, there is no way on this green earth that it could be constitutional, because the very words of the ordinance, under no circumstance, makes it constitutional. Think of an ordinance that says, an elected official has to sign up before they actually speak at their hearing. Any elected official would have standing to challenge that ordinance because on its face, it is completely unconstitutional. That is not what you have here. This is a de facto challenge. This is a challenge, and they said it on the very first night, they said it in their application. We have to look at the ordinance, we have to apply the ordinance, and they believe by applying it, they're going to show you that it's exclusionary. Okay, that's a de facto challenge. It's not looking at the face of the complaint. So when you look at their citations to facial challenges, take it with a grain of salt, read the cases, you will see all but one of the cases they cite in that section are a zoning case, and the zoning case is completely inapplicable. And you will also see in every case, even when there is a facial challenge, you need a party with standing. Period. End of story. So that gets me to standing. Standing goes hand in hand with ripeness, but it's a little different. Standing absolutely applies in every case, and there is nothing special or different about a facial case, a de facto case, a de jure challenge to an ordinance. The plaintiff still needs to have what's called William Penn standing. It applies to zoning cases and applies to every case. It is substantial, direct, and immediate interest. They have to show those three things. Otherwise, again, anyone could challenge an ordinance passed by a legislative body simply because they don't like the ordinance. First, Range did not show you any specific harm that it will suffer as a result of the application of this ordinance. In fact, they did just the opposite. The very first night their counsel said, we're not challenging anything, every one of their witnesses said, there is nothing here that we are actually trying to do. So first, I would ask you, is Range a landowner with standing? You'll recall when I read from section 916.1, you needed to be a landowner to have standing. I'm not sure the evidence submitted to you demonstrates that. What Range showed you was 3 leases. They were subsurface leases without any access or any surface rights. And that's all they showed you. They have 3 subsurface leases in this township. They didn't show you they have a right to put a well pad on anybody's township, on anybody's property in this township. And that's it. That was their demonstration of landowner. I don't think that is enough. That is for you to decide. And to the extent they are complaining about access to gas under those 3 parcels, well, this ordinance does not regulate pipelines or underground access to oil and gas, nor can it. So that part's not applicable either. Now, even if you say, okay, they're a landowner under the MPC, they still need to show this standing test, the substantial, the direct, and the immediate interest. You'll have to ask yourself, where is that direct and immediate harm? And where is that substantial interest? A substantial interest means that there is something greater than the abstract interest of all citizens in having to comply with the law. They have to show you they have something different. Direct and immediate harm. Range is operating 5 unconventional well pads in this municipality that are unaffected by this ordinance. They are currently drilling at the Connor Samuel well pad. You heard that testimony. There are no pending applications, and as I said, they haven't even thought about it. They haven't even done any geological exploration to see if they want to put a well pad in Cecil Township. And Range hasn't set forth with any kind of specificity anything that they are doing that is going to be impacted. They do, however, seem to rely on a one-off statement from one of their witnesses who said, well, maybe at some point in the future, we might be stranded at the Connor Samuel well pad. It didn't explain what that meant. Is it referring to pipelines? Well, the ordinance doesn't address pipelines. So that has nothing to do with a challenge. Are they referring to something else? I'm not sure. And if you recall, when asked further on cross-examination, he testified, not currently stranded. Not currently stranded. So again, when I talked about that interest being immediate and direct, and it can't be something hypothetical, like the Supreme Court said, that might happen in the future, what their witness said doesn't even get you a quarter of the way there. And then you'll also recall Miss Black, okay? She's the one who showed us the 3 subsurface leases without any surface rights, and she said, well, we can't reach those properties. We can't reach them from the 5 existing well pads, okay? But she didn't provide any answers as to whether Range even wants to reach those well parcels, whether they've made any efforts in doing so, or explored it in any way. Again, they do not have a property owner in Cecil Township willing to lease surface rights for the placement of a well pad in Cecil Township, period. And don't you think if they did, that would have been Exhibit A for this board? Again, their presentation over these 3 nights did nothing to satisfy standing, as is required under the law. And just for looking at these facial challenge cases, they seem to like the fact that they think a facial challenge is somehow different. I direct you to the Pittsburgh Palisades Park case. And in that case, they talked about standing in a facial challenge. And if you remember, I just said, even if it is a facial challenge, which this is not a facial challenge, you still need to have standing. And in that case, the court would not consider a challenge that didn't meet standing and where the harm was wholly contingent on future events. Range's case is wholly contingent on future events. I'd like to be very clear with the board at this point that as you assess this matter, your inquiry can end right here. Okay, you can look at standing, you can look at ripeness, you can make a determination that this case should be dismissed, and that's the end of it. Because as I said, they're threshold matters. You have to get over them to get into the merits of the case. Now, the third threshold matter that I'm going to touch on briefly is you can't have something that's moot. The case Range filed against Ordinance 9 of 2024 is moot. There were sections of Ordinance number 9 of 2024 that were significantly changed, some of the sections that they challenge, when Ordinance number 5 of 2025 was enacted. For example, compressor stations and processing facilities, they are now allowed in the industrial district. Well, that's nothing new. They have been allowed in the industrial district since 2011. Simply went back to what the old ordinance was. And from 2011 till today, they never challenged that. Other types of facilities have setbacks. Those setbacks have applicable waiver provisions. And that section is now applied in the facility section where it wasn't previously. So again, Ordinance number 5 of 2025 is significantly different than Ordinance number 9 of 2024. And all they have done as it relates to Ordinance number 5 of 2025 is try to amend during the last hearing. It was never formally advertised for a hearing period. However, and this is important, if you make a decision on standing and ripeness, that decision will equally affect a case as to Ordinance 9 of 2024 and Ordinance number 5 of 2025. There is nothing special or different that they demonstrated that would magically give them standing under Ordinance number 5 of 2025, even if it was properly advertised and even if we did have formal hearings on that particular challenge. So the standing and ripeness case, standing and ripeness issues, and the decision on those issues can render challenges to both ordinances over. period. Now, I do want to get into a little bit of the merit arguments because they have been raised. But remember, if you don't get over the thresholds, you don't have to dive into these other additional arguments. But I do think it's important to say a few words about some of these other arguments that have been presented. First of all, they had to demonstrate that this ordinance was exclusionary. That was their burden. After standing in ripeness, they had to demonstrate that. I'd ask you to let's look at the ordinance itself first. And remember that zoning ordinances are presumed constitutional, and to overcome the presumption, the challenger bears a heavy burden to show, in the case of a de facto challenge, that the ordinance completely or effectively excludes the legitimate use. If they demonstrate that the ordinance is de facto exclusionary, the case goes to the township then to demonstrate that the ordinance bears a significant relationship to public health, safety, and welfare. So let's start with use first. The case law is clear about the allowance of legitimate business uses in a municipality. So what is the use here? The use is access to the oil and gas, which is underneath the ground. With today's technology, as their witnesses testified, that extraction can take place up to 4 miles from a well pad. And as the technology increases, that distance is only getting further. So unlike a lot of the cases that Range showed you in their submission, this is not a use that takes a physical form on top, on the surface of the land that is being regulated. It's not a gas station. It's not a quarry where there is a physical location where the mineral is there and we have to physically go in and out at that location. This is quite different. So I'd ask you to please keep that in mind also as you assess these cases. I'd also like to set the record straight on some other elements of the ordinance. They raised the issue of access roads and said, well, the fact that the setbacks are from the access roads makes this ordinance exclusionary. The setbacks don't affect access roads. If you read the ordinance, there's an entire section on roads, and the setback distances clearly apply to the edge of the well pad, not the access road. They make some comments about pipelines. Setbacks do not affect underground pipelines, nor can they. There is nothing in this zoning ordinance that speaks to the siting of pipelines, period. Yes, there are increased setbacks for oil and gas well pads in this ordinance, but there is also a waiver provision. You heard a little bit about that during the ordinance. The waiver provision exists in both parts of the ordinance that they are challenging, and if Range obtains waivers from all the property owners within this 2,500-foot setback area, it can get a permit for that location. Any alleged exclusion is therefore squarely within the control of Range to address. Mr. Volz, I know you are very familiar with the South Point case because you were part of that case, and it is a Cecil Township case. And they've compared our case to South Point. But let me be very clear to the board, this case is not the South Point case. South Point dealt with what's called unlawful consent zoning. The differentiating cases that the court cited to in South Point will make it very clear that this is a completely different animal that we are dealing with. And this is some meaty stuff, but I'm just at a very high level going to try to explain it. Unlawful consent zoning is when an ordinance shows that a use is not opposed to public health, safety, welfare, or is not a nuisance and is in harmony with the public interest, but the consent of a group of individuals is necessary and must be procured before the land can be devoted to that use. The delegation of that power to that group of individuals is repugnant to the due process clause of the 14th Amendment. And that's what the court says. It is repugnant and it is unconstitutional. So an ordinance, and I'll just give it to you in actual layman's terms, an ordinance that says this children's home can only go here if 2/3 of the people on this street within 400 feet of the home say, okay, it can go there. That's unconstitutional. That's repugnant. It's delegating to individuals that ability to up or down on something, okay? There's an entirely different line of cases that support exactly what Cecil Township has done here, okay? And in those cases, and there are Supreme Court cases and there are Pennsylvania Supreme Court cases. So I would ask you to read the Perrin case, which is a Pennsylvania Supreme Court case, very clearly. I'd ask you to read the Cusack case, which is a U.S. Supreme Court case that talks about the opposite of unlawful consent zoning. So in the Perrin case, which is the Pennsylvania Supreme Court case, the consent feature applied to the allowance of a gas station in a residential district. So in other words, the owners were allowing something which was otherwise prohibited and what the court calls a nuisance. So in those kind of cases, the municipality placed the confidence in those property owners that they would not consent to loss of property value or injury to their health unless there were good cause to do so. So in those kinds of situations where there is something that is otherwise a nuisance and where the legislators have said this shouldn't go here, but if you want to go ahead and consent and waive that right, it's in your hands. Those kinds of cases, the court said, are perfectly okay. Another example in Cusack, the ordinance at bar absolutely prohibited the erection of billboards in a residential neighborhood, but permitted the prohibition to be modified with the consent of the persons who are most affected by the modification, the folks in the direct proximity of the area. And the Supreme Court said that is not an unlawful delegation of legislative power. Again, I'm going to stop there on that one. This is not South Point. So when you see in their briefs, oh, this is South Point and this is unlawful consent zoning, it's not. Again, you don't even need to go down this rabbit hole if you decide standing in ripeness. But if you do, I hope you'll now appreciate that distinction when you read these cases. And there is one quote from the Perrin case I thought was applicable. And in the Perrin case, now again, that's the Pennsylvania Supreme Court case on consent zoning. The Supreme Court said towards the end of the case, where through proper enactments, a nuisance which is prohibited is permitted under adequate safeguards and no injustice to the owner is apparent, there will be no disposition to disturb the municipal regulation by the courts. If, among those safeguards, the consent of those directly affected is necessary, the ordinance will be deemed valid. Again, these cases are different. Our case is different. There's no collective override of an otherwise non-nuisance use in our case. So, to recap on the substance issues, to recap on the actual looking at the ordinance and assessing that, first, Range has not demonstrated that this ordinance is de facto exclusionary because of the myriad of technical issues with their mapping as set forth in our submission. And I'm not going to go through all the technical details. You'll recall Mr. Limbrunner was on the stand and we cross-examined him on how he actually came up with those maps. But at a very high level, he didn't do a ground review. It was a desktop exercise. Protected structures are specifically defined in the ordinance. He didn't make any effort to differentiate those buildings. He didn't take into account unoccupied structures in any meaningful way. There was no assessment of topography and modeling. The parcel lines he used, and the county's tax maps did not correspond. He basically used the tax parcel lines as the property lines. Now, if we were actually fighting about something in particular, a little more care could have been taken to do measurements of property lines and not just tax map overlays. He also utilized municipal boundary lines as cutoffs, but they don't necessarily constitute property lines. In short, Range didn't meet the technical burden of demonstrating that this ordinance was exclusionary. Second, Range failed to assess this ordinance as a whole. Courts interpret zoning ordinance based on how they are meant to operate, not in fragmented isolation. And the waiver provision is part of this township's deliberate zoning structure. So here the waiver is an integral feature of the ordinance's function. It's designed to balance public safety and private choice, and it cannot be disregarded, in assessing the exclusion. And you'll recall that every one of their witnesses, when we asked them, well, did you look at the waiver? Did you assess that? Did you even think about that? No, we didn't. So they made no demonstrated efforts to actually assess and apply this ordinance as it was written. In closing, you do not need to get into that deep dive of an analysis of the ordinance if you can make a decision on standing and ripeness, which I think is the right decision to make. But if you do find yourself analyzing the ordinance, remember, the property right Range is talking about is access. Their business, I should say, that Range is talking about is access to oil and gas under the property. And I'd just like to direct you to the Pennsylvania Supreme Court case of Mutual Supply Company appeal. And this is an interesting case. In this case, there was a quarry under Upper St. Clair, and the owner of the quarry wanted to access the quarry from a location in Upper St. Clair that happened to be a residential neighborhood. The court said, sorry, but no. They said you're not improperly prevented from accessing subsurface resources simply because the surface structures simply because the surface structures that you were required, that you need to access those resources cannot be built on property in a particular township and must be built elsewhere. So in this case, they told him go to the other end of the quarry. It was in another township, and that's how they had to access. This was a takings case, and the court found that that did not constitute a taking. Just because you need to access your minerals from somewhere else, not a taking. I think this applies even more strongly in an exclusionary zoning case, because you can look at the facts here and say, not exclusionary. You can access those rights. You just have to do it somewhere else. And if you apply the ordinance correctly, you could do it in the township. So I would close with the fact that Range has failed to demonstrate that it has standing to bring this case before you. Range has failed to demonstrate that this case is ripe for review. And the ordinance it challenged was amended in a substantial way, so that original ordinance where we had the hearings on is moot. And in any event, if you find yourself analyzing the actual ordinance language, I think you could find that you can dismiss the case on that basis as well. So I thank you for your time and your attention to this matter this evening. Thank you.
Thank you, Ms. Moore. Mr. Ferguson or anybody else?
Yeah. Thank you, Mr. Solicitor. I just need 1 minute. So I'm on behalf of Josh and Michelle Stonemark, and I just wanted to address the participation of the Stonemarks in these proceedings in order for the board to evaluate the relationship of a proposed land use on the objector's property. You'd apply the same standing standard, which is whether they have a direct, immediate, or substantial interest. But for the reasons articulated by Solicitor Moore, the board cannot evaluate these factors as to the Stonemarks or as to the Georgetown Estates for the same reason that Range is without standing. Their challenge is in a vacuum, it's theoretical, and does not relate to any existing or proposed surface oil or gas pad in Cecil Township of which Range has established that it is the landowner. So with that, the Stonemarks rely upon the joint proposed findings of fact and conclusions of law of the opposition parties and the oral argument of the township solicitor.
Thank you, Mr. Ferguson.
Hi, Tom Klain for Center for Coalfield Justice and the Clean Air Council. I want to briefly highlight some of the procedural points that Attorney Moore made and tell you why they're truly important for this case, why they're important for actually determining the facts of the case. So this case is not ripe because Range is not developing any particular project. Their sole piece of evidence showing that the ordinance is exclusionary is a map made by Mr. Limbrunner based on data where he could only produce that map using proxies because there's no development on the ground, so there's no motivation to ground truth any of the facts used in that map. So for instance, protected structures are, that the 2,500-foot setback is from protected structures. Those structures are only protected if they are occupied or if they're being used for certain things. To approximate that, Mr. Limburner used emergency services data that he admitted may include businesses that are no longer operating, houses that are no longer occupied. So instead of actually checking on the ground which of the structures that he used to draw his buffers that show all of the pink space on the maps that Range will point you to, those are all based on hypothetical data that he said in his presentation may no longer be true. The same is true of property lines. He used tax plats to demonstrate where the 250-foot setbacks from property lines would be. He did not make any effort to figure out who owned which property, whether those tax plats were owned by one person and part of a contiguous property, in which case you would not need to look at the tax plats in the middle of a property. He used that proxy because it was a convenient way for Range to create their map without actually having to pursue any projects on the ground or ground truth any of the information they used to make their map. So, had the case been ripe, Range would have made the effort to make sure that the claims that they're making about the exclusionary impact of the ordinance were supported by the facts on the ground. It's very difficult for them to do in the abstract because where people live, what businesses they're using, what structures could be impacted by oil and gas development changes over time. So Range is not trying to develop a project. They do not know when they're trying to develop a project. So they're not able to actually get on the ground and develop the facts that would show that this ordinance is exclusionary at any relevant point. So the procedural issue of ripeness is essential for this case to be made at all. So since you're looking at both whether they made their prima facie case and whether they've met the procedural hurdles they need to, I just want to make sure that you recognize how linked those issues are and that without the ripeness, they're unable to make their case.
Thank you.
Joshua Brown for Georgetown Estates. I'm just going to echo all the comments made by fellow opposing parties here, and I'd like to reserve our right to rebut statements made by Range Resources.
All right, thank you very much. Ms. Brown, on behalf of Range Resources, now is your opportunity.
Thank you, Mr. Bolts. With your permission, since I can't see when I stand, like what's so low, I'll remain seated.
Absolutely.
Thank you so much. Mr. Volz and members of the board, Range is not here simply because it doesn't like an ordinance. It wouldn't have spent the time and the resources to appear before Your Honor, before this board, and Mr. Volz, if that was true. It's because it believes in the rule of law. It is on. I'm sorry, I don't know what else to do. Thank you. Hopefully this helps. Is that better? No, actually I can't. Let me get a little closer. As I said, Range is here because it believes in the rule of law. And because Ordinance 5-2025, like the 2024 ordinance before it, improperly excludes all oil and gas development in Cecil Township. The Township Board of Supervisors, despite their duty to apply the law, passed these ordinances with the knowledge that it could not legally exclude oil and gas development in Cecil Township. Indeed, for years before they passed the 2024 ordinance, from 2011 until that time, Cecil Township zoned oil and gas development under ordinances which permitted oil and gas development as a conditional use within the township's oil and gas overlay district. And in adopting those prior ordinances, the Board of Supervisors specifically recognized that under Pennsylvania law, quote, Cecil Township may not exclude oil and gas development from all zoning districts. The Board of Supervisors also had recent experience regarding how waiver provisions in a prior ordinance, that's the South Point Golf Club case that was referred to earlier. Just in 2021, the Commonwealth Court rejected the Board of Supervisors' ordinance and a waiver provision because it was improper under Pennsylvania law. That waiver provision in the South Point ordinance was actually more developed than the one that appears here, which gives absolutely no criteria for whether a landowner or, let me step back, an owner or occupant of a protected structure gives a thumbs up or a thumbs down to waiver. And without any criteria, that's an improper delegation of the Board of Supervisors' authorities to legislate. You can't just give it to a property owner to do as they please. That's the Board of Supervisors' responsibility. More recently, the Washington County Planning Commission in August of last year advised the Board of Supervisors that its then proposed amendments, which were less exclusionary as far as setbacks are concerned than the ones that actually were adopted, they stated that they appeared to create a situation where most of the land in Cecil Township would not allow for reasonable development of oil, gas, and other minerals, which would render the ordinance exclusionary. This is the Planning Commission, not Range, the Planning Commission, saying this to the Board of Supervisors. And additionally, at a May 8th, 2024 public hearing, again on an earlier iteration of the proposed ordinance, the Board of Supervisors chairperson, Tom Casciola, recognized that extending setbacks beyond 1,500 feet would be, quote, effectively banning oil and gas developers by zoning. Mr. Casciola further acknowledged at that same public hearing that the township must follow the law, that it can't ban business, including oil and gas development from the township, and that it could not enact setback distances that preclude oil and gas drilling in the township, saying we have to follow the law. Casciola at that time acknowledged we can't just disobey the law. You have to have an issue. If you have an issue that comes from with a law that comes from the state, then you have an issue with our state legislatures to change that law. We, the Board of Supervisors, he meant, have to follow it. Nobody on this board can vote for something that violates the law. And those statements came in response to comments, according to Mr. Casciola, mostly emails, standard emails, asking the township to put a 2,500-foot setback from protected structures. Exactly what we have here. And at that time, Mr. Casciola recognized that it was a violation of Pennsylvania law. Yet despite that knowledge, the Board of Supervisors passed an ordinances with setbacks that far exceeded the 1,500 feet that the chairman was talking about during his comments during the May 2024 hearing. Range is here seeking from this board the application of Pennsylvania law, pure and simple, based on the facts and based upon the impact of the ordinance. And we find that the evidence overwhelmingly proves that the challenge ordinance excludes oil and gas development which is a legitimate business use as recognized under Pennsylvania law. The challenge that Range has advanced is a de facto exclusionary challenge, that the ordinance is de facto exclusionary. There have been there's been some discussion about what that means. I'll tell you what I think is important for this board is what the PA Supreme Court says it means, because that's the governing body that determines what the law is in this Commonwealth. And the PA Supreme Court said in 2009 that in a de facto exclusion case, the challenger alleges that an ordinance appears to permit a use, but under such conditions that the use cannot, in fact, be accomplished. And that's what we have here. We have an ordinance that appears to permit oil and gas development as a conditional use, but under such conditions, i.e. the challenge setbacks, that the use, oil and gas development, cannot in fact be accomplished. So Range's challenge is a de facto exclusionary challenge. It's been the law of Pennsylvania for decades, 50, 60 years, that municipalities generally may not enact zoning ordinances that totally prohibit legitimate businesses from their borders. We've cited a number of cases. Mr. Volz has them. You have them in our submissions. But it's clear that in the challenge of this nature, there is a burden shifting framework. And I think one of the few things that we agree with the township's council is that they acknowledge the same burden shifting criteria that is applicable to these proceedings. The challenging party in ranges that bears the burden to show that the ordinance in question completely or effectively excludes a legitimate use. And once that challenger makes its showing, the burden shifts to the municipality to make its showing through evidence that the total exclusion bears a substantial relation to the public health, safety, morality, or welfare. The municipality has not put on that evidence. That's not under consideration tonight. The consideration is, did Range in fact prove that the ordinance in question completely or effectively excludes a legitimate use? None of the township or conditional objectors contest in their motions whether oil and gas development is a legitimate use. And in fact, they couldn't. A legitimate use is evident in the fact that there is a comprehensive government regulation of oil and gas development. You heard that through Mr. Mantinko's testimony in detail about all the ways, actually a few of the ways, which were extensive as to how Range is in fact regulated by the government. And under Pennsylvania law, closely regulated but permitted uses, like oil and gas development, qualify as legitimate under the law. And there's also been recognition that Pennsylvania, in fact, under the law, encourages its law, the optimal development of oil and gas resources in the Commonwealth. And there have been Pennsylvania courts that have expressly recognized that oil and gas is a legitimate business activity. And so I submit to you that the issue as to whether or not oil and gas activity, the development is a legitimate use, has not been opposed by anyone. And so that has been established by Range. And the only remaining issue is whether or not the ordinance excludes oil and gas development. And I submit that we've proven that far and above any standard of proof applicable to Range. Here, the ordinance 5-2025, like its predecessor, ordinance number 9-2024, is a de facto exclusion of oil and gas development in Cecil Township because while the ordinance nominally allows oil and gas development as a conditional use, the setbacks prevent any new oil and gas development. Now, Pennsylvania courts have repeatedly invalidated ordinances that have imposed exclusionary setbacks. Back in 1964, in the Eller case, the Pennsylvania Supreme Court invalidated as exclusionary an ordinance that required mushroom houses to be set back 500 feet from any roadside and 1,000 feet from any property boundary, because when those setbacks were applied, they resulted in a requirement that the mushroom house sit in an unreasonably large plot of land that could not be justified, rendering the ordinance constitutional. And notedly, the court found that the constitutional issue could be reached based on the setbacks in the ordinance alone, and that the ordinance's constitutionality was a proper issue for determination. There are several other cases that we've cited in our submissions. I'm not going to go into those in detail, but they all support the same proposition of law. Setbacks that are exclusionary are illegal under Pennsylvania law, and there is just a multitude of cases that find so. So what is it about this ordinance that Range claims is exclusionary? To understand that, we've got to go back a little bit to Mr. Mintinko's testimony about oil and gas development. The fact that oil and gas development is a phased process that requires operators like Range to obtain land use permissions, construct infrastructure, including well pads and drill wells, and then transport that produced gas through pipeline networks. Prior to drilling a natural gas well, Range must construct a well pad and an access road. You need to have a well pad and a way to get there, is I think approximately what Mr. Mintinko said. And he testified that Range needs around 15 acres to develop a new pad, including the access road, although the well pad itself is generally around 3.5 acres. Because the access road is what connects the access to the well pad, to the public roadway, that access road, I think it's obvious, is going to necessarily come within 250 feet of a property line, right? You've got to, from a public roadway, you've got to cross into property. And crossing into that property, you're going to cross a property line. And I'm going to come back as to why that point is important and why the ordinance is on its face exclusionary because of the interpretation and the definition of well pad and well sites. Mr. Mintinko also testified that after well pads are constructed and drilled, Range can't produce natural gas until permanent production equipment has been installed at the pad and a gathering system has been placed to connect the well to market. And he also testified that a gathering system, something that's referred to in the ordinance, is, quote, a pipeline and associated compressors and other motorized equipment, including connecting the well site to an available process point. So a gathering system is it includes pipeline. And gathering system is included in the ordinance, and there are setbacks related to gathering systems. A gathering system, because it is part of the process that takes the gas from the wellhead to the market, necessarily has to cross property lines. They're not only going to cross kind of the individual property lines, but multiple property lines, most likely, to effectuate its purpose. So that's the background as to how setbacks can potentially, what the scenario is that is going to impact or be impacted by the setbacks. So the ordinance's setback provisions for well pads and facilities are essentially identical. They're in different places in the ordinance, but they have the same setbacks provisions. For well pads and for facilities, which include gathering systems, the setbacks extend 250 feet from property lines, 2,500 feet from protected structures, 5,000 feet from schools and hospitals, and 1,000 feet from subdivision lot lines. Now, both ordinances, the 2024 and the 2025 ordinance, define well pad in a way that is very important. It states, and again, it's in black and white in the ordinance, and our proposed findings of fact are identical on this issue. A well pad is the same thing under the ordinance as a well site, because that's the way it's defined. The ordinance defines a well pad as an area which includes the perimeter of the surface area of drilling operations, and states that a well site or site shall consist of the area occupied by any of the facilities, remember that word facilities? Think gathering system facilities, because that's what the definition includes. Structures and equipment associated with or incidental to the construction, drilling, fracturing, production, or operation of an oil or gas well. And if multiple areas are used, then the total combined area shall be considered the well site. And then that definition goes on to say, also referred to herein as well pad. And so what the ordinance does is that it defines that broad area of well site that includes the facilities, the gathering systems, as well as any construction related to oil and gas development. As the well site, it's also under the ordinance defined as the well pad. So that whole area, which necessarily has to include the access road because it's part of the construction of the well site, is known under the ordinance, also known as a well pad. And that's important. The expanded definition under the ordinance of well pad is important because of the impact it automatically has on your ability to site a well pad. Even before you get to many of the other setbacks, because there is a setback for property lines that is drawn from a property line, like so far from the gas pad has to be so far from the property line. This ordinance automatically precludes the structure of a gas well pad, because you can't get access and build access to the well pad without violating that setback provision. And you can't install gathering facilities that take the gas from the well to market without violating that setback provision in every single instance. That's the way the definitions are drafted, and that's the application of the ordinance. So it is, on its own, looking at the ordinance itself, exclusionary, because you can't do anything without a waiver. Now, Range went further and also showed the physical application of the setbacks. And you will recall that Mr. Limbrunner was here and described in great detail, based on his 40-plus years of experience as a GIS expert and mapping in that area, what occurs, what is the result of the application of the ordinance setbacks. He showed that those ordinance setbacks totally precluded oil and gas development in Cecil Township by virtue of applying just 3 of the setbacks: the 250-foot setback from property lines, the 5,000-foot setback from schools, and the 2,500-foot setback from protected structures. And when you apply just those 3 setbacks, not the hospitals even, not the setbacks relating to subdivisions, which are 1,000 feet, just those 3 setbacks, the entire surface of Cecil Township was covered. There was no place to put anything. If you layered on, keep in mind, the ordinance doesn't stop there. There's 5,000-foot setbacks from hospitals that add 5,000-foot areas of non-waivable setbacks. Full setbacks are non-waivable too. And the 1,000-foot setback from subdivision lot lines layers on an additional level of exclusion. I think it's important to note that range, and this is kind of harped a lot on in some of the submissions. The evidence showed that Range operates 5 existing well pads in Cecil: the Engel, the Troyer, the Augustine, the Schultz, and the Connor Samuel. Range, as the operator of those pads, applied for and obtained conditional use permits for its existing well pads under the prior ordinances that were in effect at the time, 9-2011 and 10-2011. And that evidence was introduced during the course of the hearing through Mr. Mentinko. Now, Ordinance 9-2011 defines an operator as, quote, any person, partnership, company, corporation, and its subcontractors and agents who has an interest in real estate for the purpose of exploring or drilling for producing or transporting oil or gas. And I note that because Range is recognized as an operator, because it got conditional use to actually pursue those well pads. And the ordinance itself recognizes Range as an operator as having an interest in real estate. We'll get back to that when we get to the MPC and landowner, for the purpose of exploring and drilling for producing and transporting oil or gas. You also heard testimony from Mr. Mentinko that in February, as of February 17th, 2025, the Connor Samuel well pad had been constructed. Range had acquired the necessary permits for drilling, and drilling had commenced. You also heard from Mr. Mentinko that once the Connor Samuel wells have been drilled, however, Range will be unable to start producing natural gas until production equipment has been installed and the gathering system has been placed to move gas from the well pad to market. That means that unless Range can install the gathering system, it can't move its gas from Connor Samuel. Now, Connor Samuel well pad is a prior permitted use. The well pad operations itself have been approved. The installation of the gas gathering equipment would be subject to the current ordinance. And currently, that gas gathering facilities, which are precluded under the ordinance because of the setback provisions, cannot be installed. And that Connor Samuel gas will be stranded once it's capable of being produced if the gas gathering lines cannot be installed. The ordinance precludes the installation of those lines under its own definitions. I note that there are assertions in the township's submissions that take some liberties with the evidence that were introduced. Township has claimed in finding of fact 171 and 212, maybe other places as well, that there's no evidence that the ordinances have restricted or prohibited Range from oil and gas development. That's clearly false because it's happening at Connor Samuel right now. There also were critiques in the submission of Mr. Limbrunner's testimony. Mr. Limbrunner, as you may recall, was accepted as an expert by the board. He was well qualified as an expert in GIS and mapping. And I'd like to address some of the critiques. Although they weren't highlighted today, I think it's important because they are asserted in the record submissions. There were some critiques of Mr. Limbrunner's testimony and his methodology. Despite his decades of experience in educational leadership in GIS and the mapping field, they attempted to discount what is unrefuted record evidence in the record that his methodology for mapping the Cecil ordinance setbacks is generally accepted in the field of GIS, meaning that it's typical and expected in that field. There were claims that he did not check the accuracy of information used. That's incorrect. He testified to the use of case maps and borders and where he got that information, much of it from government sources, and that this is generally accepted practice for GIS professionals. You didn't hear any evidence from anyone, the township or anyone else, as to how it maps its ordinances or the setbacks in its ordinances. And because I would suggest to you that it's exactly the same way if they're following what is generally accepted in the field. But there's no evidence that's been submitted other than lawyers' suggestions that perhaps something wasn't proper, that what he testified as generally accepted methodology is what is done when mapping setbacks for use in ordinance or other regulatory purposes. And he wasn't cross-examined with any different suggestion on how the township's own maps would somehow use a different methodology. I think there's a reason for that, and that's because they're, to the extent that they're doing it consistent with methodology that's practiced in that field, everyone does the same thing. It's also not true that Mr. Limbrunner's map somehow improperly used a municipal border as a setback point. There was some confused questions in the transcript on this point, but there's no evidence that there was any such application on the map, and the map itself shows areas where areas beyond the setback exclusions actually meet up with the township border. And so that the map in itself refutes the suggestion that he somehow did not properly apply the setbacks around the municipal borders. There's a suggestion that Mr. Limbrunner applied the 250-foot buffer to any property line within Cecil Township, including properties that extended beyond Cecil Township. But that's not true. He did apply them properly, and the map itself shows that. There's areas where the green areas that were the areas that were beyond the setback actually meet up to the municipal border. And so that shows that he was actually properly applying those setbacks. Their claims that topography might affect the setbacks are totally unsupported critiques of Mr. Limbrunner's methodology. Neither the ordinance nor generally accepted practice in the GIS field considers topography and mapping setbacks. The ordinance doesn't say the setbacks would follow the topography. And in the GIS field, it's how the crow flies. You measure it directly. You don't measure it based on hills and valleys. And what ordinances existed in a voided ordinance, an ordinance that had been voided, is totally irrelevant to Range's challenge of the 2024 and now the 2025 oil and gas ordinance setbacks. There's a critique of Mr. Limbrunner's application of the setbacks because he did not apply the 1,000-foot ordinance setbacks from approved subdivisions. Now, those setbacks would replace or be more exclusionary than the property line setbacks. What he did was a more conservative exclusion. If he had actually mapped those 1,000-foot setbacks, it would have been worse, not better, for oil and gas development. If you can get worse, I mean, it's double down exclusion. And I also note that certain liberties were taken with regard to Mr. Limbrunner's testimony as to occupied structures in finding of fact 86 and 197 particularly, claiming there was some kind of admission of inclusion of vacant structures in his analysis, and I heard some of that in some of the statements from counsel, respectfully. That's not in there. You look at the transcript, he never admits that he intentionally or unintentionally included vacant structures. He said simply what he said on direct examination, which is he obtained the data from the government databases. This is generally accepted practice, and what those databases were intended to represent. The speculation is from counsel that something might be vacant, but there's no evidence that there was anything vacant, and Mr. Limburger didn't admit that anything was vacant, or he included vacant properties in his analysis. There's also criticism that Mr. Limburger failed to consider whether Range could install a new well pad or gathering facilities, which is puzzling, because the whole purpose of his presentation was to show his analysis, which is that isn't possible under the new ordinance. You can't. His testimony was that you can't install a new well pad or have oil and gas development in Cecil Township because of the setbacks. There are arguments that have been advanced. I'm going to move off on Mr. Limburger's testimony, but there's arguments that have been advanced by the township and the conditional opponents that oil and gas development already exists in Cecil Township, and therefore it can't be exclusionary. I'm not going to spend a whole lot of time on this because they didn't spend a whole lot of time on this, and it's likely because, I submit, that the case law overwhelmingly disproves that argument. An ordinance is unlawfully exclusionary if it fails to provide for a legitimate business use as a permitted use, not just a legal nonconforming use. So the fact that there are legal nonconforming uses with Range's existing well pads is irrelevant to the question before you today. If it's exclusionary because it doesn't permit a new use, then it's exclusionary. What existed previously doesn't matter, and there's just a plethora of cases that support that, and they are in our submission. For similar reasons, the possibility that a landowner might pursue and obtain a variance is irrelevant to whether ordinance number 5-2025 excludes oil and gas development from Cecil Township. An ordinance cannot be upheld against constitutional attack because of the possibility that an occasional property owner may carry the heavy burden of proving sufficient hardship to receive a variance. That's the law of Pennsylvania. And so if the possibility of obtaining a variance from an exclusion that exists in the ordinance is not sufficient under the law to allow that ordinance not to be exclusionary, you can imagine that a waiver that has no criteria other than a landowner's or owner or occupant of a protected structure's random thumbs up or thumbs down is also not sufficient under the law. I want to make this clear. A variance, the existence of a variance procedure for an ordinance that is exclusionary does not save that ordinance under the law from being exclusionary. If that is true, a waiver can't either, because a waiver is even a lesser standard of criteria and chance of getting a use to be approved. It's also irrelevant that oil and gas in Cecil Township might possibly, but under the record, there's no evidence that it would be, or there's a site available for it to be, reached from well pads outside of the township's borders. There's a Pennsylvania cases, it's the Quarries case that I think was mentioned by the Township's Council. The possible availability of alternative sites somewhere outside a municipality on which the totally banned business may be conducted does not make permissible the deprivation within the township of property rights imposed by a municipality-wide ban of a particular type of business. In other words, you can't justify a township exclusion of business based on the fact that they can do it over the border. That's not permitted under Pennsylvania law. And there's also no evidence in the record that there is land available outside of Cecil Township. I think the most that's in the record is from Ms. Black, who is not an oil and gas or petroleum engineer, and she doesn't deal with siting, and she doesn't drill or determine the geology associated with sites, said that it might be possible. That's not evidence that a site even exists, and there is none in the record. The waiver provisions that the township is hanging its hat on to try to save itself from the impact of a challenge to an exclusionary ordinance like they have passed doesn't save them because they're invalid under the law. And they're invalid under the law, and they know it to be true because waiver provisions that were very similar were invalidated by the Pennsylvania Commonwealth Court in 2021, and those were waiver provisions that were passed by the Board of Supervisors of Cecil Township. It's under the MPC, the power to legislate zoning is reserved to the municipal governing bodies. The MPC does not contain any provisions authorizing municipalities to delegate their zoning powers. That's a quote from the South Point Golf Course case. Elected officials have a constitutional duty to make policy decisions and judgments inherent in zoning. These can be difficult decisions, but that's their duty. That's their obligation. And if they don't want to fulfill their duty, then maybe they shouldn't take the job. They may delegate that authority only through, they may delegate that authority under the law only through an enactment that includes adequate standards which will guide and restrain the exercise of the delegated administrative functions. Again, there needs to be, quote, adequate standards which will guide and restrain the exercise of the delegated administrative functions. And the delegated administrative functions here are the waivers. There needs to be adequate standards. This is what happened in the South Point Golf Club case. There are 0 standards in this ordinance with regard to how owners or operators of protected structures which are permitted to grant certain waivers are to exercise that authority. It's clear under the law, this is an impermissible delegation of the Board of Supervisors' constitutional duty. And what happens when there is an unconstitutional delegation of authority? The law says that those provisions in the ordinance are void. That means they are not operational under the law. They're not recognized by the law. So like in the South Point Golf Course case, the ordinance provides no standards for the owners or occupants of protected structures to follow. Instead, oil and gas zoning determinations in the township are left to those owners or occupants of protected structures who can decide to waive or not waive the ordinance's setbacks for any reason whatsoever. The delegation of zoning authority that, quote, injects private preferences and concerns into municipal zoning determinations is not permitted under the law. And an unconstitutional law is void, as is no law. That's what the Pennsylvania Supreme Court says. So the waiver provisions are void. They can't save the exclusionary zoning. And even if they were applied, they couldn't have saved them because, again, as I mentioned before, remember I told you about the variance procedure? The availability of a variance procedure can't validate an otherwise exclusionary ordinance, and therefore a waiver cannot either. And here, the party seeking develop to oil and gas in the township would face an even heavier burden than trying to seek a variance. Rather than show entitlement to a variance where the process is laid out, criteria are known, the party has to obtain individual permission waivers based on their whim from every owner or occupant of a protected structure in the setbacks. And members of the board, you saw the scope of the setbacks. Imagine how many would have to be obtained. Also, the waiver provisions in the ordinance are limited, and they only apply to certain setbacks. Owners and occupants of protected structures may only waive the 250-foot setbacks from property lines, the 2,500-foot setbacks from protected structures, and the 1,000-foot setbacks from approved subdivision lot lines. I will note, members of the board, that that's Range's reading of the ordinance. The township suggests that the waivers may only apply to the 2,500-foot setbacks. And they say in their proposed findings, I believe the language is along the lines of, with regard to the other setbacks, the 250-foot and the 1,000-foot, that the ordinance is silent. Now that's even worse for them. I don't believe that that's the correct interpretation. I think the ordinance allows for waivers of those setbacks, but that possibility of waiver won't apply to Range's Connor Samuel well pad. And that's because that well pad is situated within the 5,000-foot setback from a school, which is unwaivable under the ordinance. So the testimony was unrefuted that Connor Samuel sits well within that 5,000-foot setback. That's an unwaivable setback. And without relief from this board, Range, according to the ordinance terms, that requires setbacks for gas gathering facilities, which include those gas gathering lines, Range will be precluded from producing and marketing that natural gas. That's the evidence that exists with regard to the exclusion. Now I'm going to go quickly through the standing and other arguments.
Ladies and gentlemen, please let her finish her presentation without any interruptions from the audience.
Mr. Volz, if there was an agreement to waive the standing arguments, I'd be happy to stop now. But since there is a challenge to standing ripeness and mootness, I'm going to continue on and address those with your permission. The standing to bring a substantive validity challenge before the board is governed by the MPC. The MPC provides two persons with standing to challenge the substantive validity of an ordinance that appears before the board. Either a landowner for whom the ordinance prohibits or restricts the use or development of land in which he has an interest, and B, a person aggrieved by a use or development permitted on the land of another by an ordinance. And counsel for the township was correct. Range is pursuing it under the first provision as a landowner for whom the ordinance, quote, prohibits or restricts the use or development of land in which he has an interest. Range has standing to challenge the exclusionary ordinance under the first section as a landowner for whom the exclusionary ordinance prohibits or restricts the use of development of land in which it has an interest. As a landowner proceeding under that section, Range does not have to show that it is separately aggrieved. That's what the other provision requires, not this provision. Now, there are three different ways why Range is a landowner. Three different ways that it meets the landowner status. Landowner, under the MPC's definition, includes the legal or beneficial owner or owners of land, including the holder of an option or contract to purchase, a lessee, if he is authorized under the lease to exercise the rights of the land, or any other person having a proprietary interest in land. Remember our argument back about the conditional ordinances where range got conditional approval, use under the ordinances that existed before the 2024 ordinance, and how it is an operator, and how those ordinances themselves recognize that range as an operator has an interest in real estate? That's a hook as to one of the reasons why range is entitled as a landowner, as having an interest in real estate as an operator. It has a proprietary interest in land. So under the Pennsylvania law, having a proprietary interest includes a property interest. That's the Pennsylvania Commonwealth case of Tioga Press, and it's a 2009 decision. Proprietary means holding a property or a proprietary interest as the interest held by a property owner together with all pertinent rights. Range qualifies as a person having a proprietary interest in the land by virtue of its property interest in Cecil in two ways: through Range's oil and gas leases, and as an operator of its existing well pads in Cecil Township, as I just mentioned. Range's oil and gas leases give it property interest and thus a proprietary interest in the land because leaseholds are property interests under Pennsylvania law. In the Marshall Township Board of Supervisors 1998 Pennsylvania Commonwealth decision, it notes that a leasehold gives a lessee a property interest in land such that he is an other person having a proprietary interest in land. So if you were a lessee, you have a proprietary interest in land. Range's leasehold in Cecil Township include those 3 oil and gas leases that you heard Ms. Black talk about and we introduced into evidence. Oil and gas leases in particular reflect a conveyance of property rights within a highly technical and well-developed industry. That's a quote from the Pennsylvania Superior Court in the McLaughlin case. There's a similar quote that says, quote, an oil and gas lease is considered a conveyance of a property interest. That's the Shedding case, Pennsylvania 2016 case. Thus, it's clear under Pennsylvania appellate case law that Range holds a proprietary interest in land under Range's oil and gas leases, which grant Range the exclusive right to all of the oil and gas contained within and underlying the property that's leased. Range also has a property interest and thus a proprietary interest in the land as an operator of the existing gas wells. And I've talked a little bit about that. Range applied for and received those conditional use permits from the township and was recognized as an operator. And under that ordinance, an operator is defined as, again, any person, partnership, company, corporation, and its subcontractors and agents who has an interest in real estate for the purpose of exploring and drilling for, producing, or transporting oil and gas. And so as an operator under those prior ordinances, Range is considered to have an interest in real estate. Range is also a landowner under the MPC because it's a lessee authorized under the lease to exercise the rights of the landowner. It's another way under the definition of landowner under the MPC that you can be a landowner. And we've cited cases that address this point as well. The right of property in natural gas and oil ordinarily belongs to the land, and the oil and gas are part of the land so long as they are on it or are subject to the control. Range acquired through the oil and gas leases the right to the subsurface oil and gas and the right to develop those resources. Those under the law are part of the land. Range's oil and gas leases therefore give Range the ability to develop the oil and gas as if it was the landowner, exercising the rights the landowner would otherwise hold. That's the purpose of the lease. That is, Range's oil and gas leases allows Range to stand in the shoes of the landowner, qualifying it as a lessee under the MPC and by extension, a landowner. The township and the conditional objectors' counters to this argument are wrong in arguing that Range's lease agreements don't give Range the broader rights of a landowner. There's no authority cited in support of that proposition, and it's contrary to Pennsylvania law, which I've cited ad nauseum now about the different ways why Range is a landowner. To the extent that the township suggests that Range must have all of the broader rights of a landowner, every single right of a landowner, to qualify as a lessee under the MPC, then a lessee, as the township would have it, would not really be a lessee at all, but they would just merely be the owner. I mean, you can't have it both ways, right? So if the Pennsylvania appellate courts say that oil and gas rights are a property right, then the leases that grant those rights grant Range property rights, and therefore it is a property owner. And Range is also qualifies as the legal or beneficial owner of land. The term land includes real property. Any real estate interests in land, either legal or equitable, easements, incorporeal heterotrements, and also the mineral under the surface. That's Black's Law Dictionary. Oil and gas leases, rights under a lease, are a property interest characterized as real property. That's, again, Pennsylvania Superior Court case. And the Superior Court in 2019 noted that it's well recognized that oil and gas leases involve property interests. So this idea that Range isn't a landowner, that it doesn't have standing under the MPC, there's three different ways to Sunday how Range becomes a landowner under the definition of the MPC. And why is that important? Because it gives Range standing. Simple as that. Range is a landowner. It has standing under the MPC. The township suggests in its submission that Range has to provide some kind of documentation that the lessors of the land in which it claims an interest have consented to Range's filing its challenge. There's no case law that says that. They don't cite any authority for that. There is no authority for that. But even if it was the law in Pennsylvania, we actually would meet it. It's not the law, but we would meet it. And that's because the record reflects that several Cecil landowners, including Mr. Monaco, the trustee of the trust that is the lessor for one of Range's oil and gas leases in the record, supports Range's challenge. So the township's argument isn't the law of the land, but even if it was, we would meet that standard. The township attempted to discredit Ms. Black's testimony. She was the Range Resources individual who testified about the oil and gas leases. They attempt to discredit her testimony that the oil and gas subject to the leases is stranded by not accurately representing her testimony in the submissions. I think this is important because it's not been raised, but it's submitted. And I don't want the board or the solicitor, Mr. Solicitor, to be misled. I'm not saying it's intentional, but to be misled. Ms. Black did not testify that she could not identify where the leased property was located. That's what they say. In fact, the evidence shows where the leased property is located. The addresses are on the lease. And she testified to those leases and who the leases were with, and they're in the record, and the addresses are there. So she didn't testify she didn't know where these properties were. She merely said that she could not, on the spot, point to exactly where those properties were in a map. She was under oath. She didn't want to guess. So it's kind of a non-issue, but I wanted to point it out, and that's finding of fact 106, Mr. Waltz, the township. Township also misconstrued Ms. Black's testimony in its finding of fact 119, relating to the claimed knowledge of Range's hardship as a result of ongoing proceedings before the board. She was asked about, in fact, the hardship as a result of the zoning hearing board not having rendered a decision on the challenge yet, which is a distinction. I think I noted before that Range doesn't need to show that it's aggrieved by the exclusionary ordinance in order to have standing. I'm going to not go into those arguments because they are laid out in detail, and there wasn't really anything addressed on those issues by the township or any of the other opponents. It's clear that the cases cited by the township have nothing to do with the MPC, which this challenge is proceeding under, and they concern judicial review, not review by the zoning hearing board. The standing is established by virtue of the MPC and the requirements of the MPC by statute, and Range meets those requirements. Moving on to ripeness. The township and the conditional objectors rely on an incorrect standard of ripeness in their motions to dismiss. They don't cite to, nor do they even recognize the standard that applies to facial challenges like Range's. The case law is abundantly clear, undisputed in Pennsylvania, that while as-applied challenges require application of the ordinance to be ripe, facial challenges are different. Range has a facial challenge. And the facial challenges are ripe upon mere enactment of the ordinance, meaning as soon as the ordinance is passed, it's ripe to challenge it, assuming that you have landowner status or are an aggrieved party under the MPC. A facial challenge maintains that no set of circumstances exists under which the challenge law would be valid, and that the law is unconstitutional in all its applications, which means you don't apply it to a particular piece of property. You don't apply it to, a particular area in the township. Facial challenge means there's no circumstances ever, whether it's this piece of property or that piece of property, in which the challenge law would ever be valid. And that's different from as-applied challenges. As-applied challenges are those where you are seeking a particular, you're saying the ordinance is unconstitutional and exclusionary as to this use that I want to use right here. And I'm not allowed to proceed with my permits because of this ordinance, and I think it's unconstitutional. That is a legitimate challenge, but that's not Range's challenge. Range has the right to pursue a facial challenge, and that's what it's done. So in the substantive validity challenge, the courts have recognized for decades that exclusionary challenges like Range's are facial challenges, and that such evidence in support of excluding a particular use at a specific location is irrelevant. Let me say that again. Pennsylvania courts have recognized for decades that exclusionary challenges like Range's are facial challenges, such that evidence in support of excluding a particular use at a specific location is irrelevant. And that is the General Battery Corp case. It's a 1977 Pennsylvania Commonwealth case. That's what that case stands for. And in that case, the court said the application of an ordinance to a challenger's proposed use of land is not dispositive on the issue of the ordinance's facial invalidity. And there are several other cases that we've cited to the same effect. To the extent that the ordinance asserts that Range must develop and then present concrete plans for specific uses on specific property to maintain the validity challenge, that argument is contrary to the MPC, which does not require the applicant in a substantive validity challenge to submit development plans to the board. That's in 53 PS section 10916.1C1 of the MPC, and also is supported by the Pennsylvania's 1993 decision in the Budco Theaters case. None of the township or conditional objectors address ripeness of facial challenges at all. Instead, they argue that Range's challenge is not ripe under standards that don't apply. And so those arguments are irrelevant. But even if the standards were applied to Range would meet them. Why? Because the issues are adequately developed for review. That's the first standard for other ripeness tests. And there's a requirement that the parties will suffer hardship if review is delayed. So that's reflected in the Pineco case. I want to talk about the Pineco case, which is the Commonwealth Court decision that was cited earlier by Township's counsel. That case applied the two-factor test, that one I just talked about, adequately developed for judicial review and harm or hardship. They applied that two-factor test to ripeness to an exclusionary zoning challenge without addressing whether the challenge was a facial challenge that was automatically ripe. They just didn't consider the issue. It wasn't raised by anyone. That doesn't mean that it is not the law, because other cases have so held. The Commonwealth Court did so, however, in the context of a case where the challenger did seek site-specific relief, turning on considerations specific to the property at issue, as would be true in an as-applied challenge. So maybe that's the reason why they did it. We don't know. The court doesn't tell us. But we do know that that was the situation in that case. And that's not our case. We have a facial challenge. So how are the issues adequately developed for review, even though this standard doesn't apply to Range? The issues are adequately developed when, as presently written, the zoning ordinance does not permit the use the challenger seeks to commence in any zoning district throughout the municipality. That's the Pineco case. And that's what we have here. It's not permitted. As presently written, the zoning ordinance doesn't allow Range to develop oil and gas in any zoning district throughout the township. The existing facts already developed by Range establish the legal theory of its challenge. The application of the setback provisions in the ordinance exclude oil and gas development throughout the township. Further factual development is the question. Is it needed? No. Why not? Because we've already shown you can't get any more exclusionary. You're not going to need to develop any more evidence because we've already submitted it. The township and the conditional objectors contend that Range has no pending applications to develop additional well pads, rendering the challenge somehow unripe, and relatedly, the MPC requires a specific land use proposal. These arguments have been expressly rejected by the Commonwealth Court. That's the Budco Theaters case. In that case, the zoning hearing board and the trial court dismissed a landowner's substantive validity challenge where the landowner had not submitted a development plan. The Commonwealth Court reversed and found the MPC's plain language did not require a landowner proceeding under this same section of the MPC Range is proceeding under to, quote, submit plans, and that the board and the trial court erred by dismissing the landowner's substantive challenges. So I submit to you, the Budco case, Pennsylvania Commonwealth Court, has already said it can't dismiss Range's challenge because it didn't submit particular plans for a development, as the township and the opponents would lead you to believe Range is required to do. It's not. Pennsylvania Commonwealth Court has said it's not required, and the MPC says it's not required. The other factor in the two-factor test that doesn't apply, but Range still meets it anyway, is whether whether Range will suffer hardship if review is delayed. Even where it's considered, this hardship prong is largely irrelevant in cases in which neither the agency nor a reviewing court have a significant interest in postponing review. What's the problem with proceeding? Why would there need to be a postponement of review? We're willing to go forward. Here, neither party has an interest, a valid interest, in delaying review of this matter and having the board make a decision on the merits. Delaying review would result in substantial expense and uncertainty that results from trying these matters piecemeal. Pennsylvania is particularly sensitive to such concerns in cases like these that involve industry-wide regulations. And on this basis alone, the board should find the requirement met to the extent it applies. Where it applies, the hardship prong asks whether the challenged action creates a direct and immediate dilemma for the parties. That's the standard. Such that the lack of pre-enforcement review will put the parties to costly choices. A showing of hardship does not generally require the challenger to take actions that would be futile under the law at issue. In this instance, Range will suffer hardship if review of the ordinance is delayed. Both ordinances preclude well pad setbacks that prevent Range from establishing new well pads anywhere in the township. Range has already acquired and made payments under Range's oil and gas leases, which cannot be accessed from existing well pads. Those are stranded. And the ordinance prevents Range from accessing its exclusive rights to all the oil and gas under those leases. Range also faces hardship resulted from the limited choices imposed by the ordinance. What choices would it have? Range may develop plans for new well pads that aren't permitted. Under the ordinance, we know it's excluded. The entire township is included. So what are the choices? That it develops plans for something that's already excluded? That it develop plans and proceeds with construction of a new well pad to reach those leases, subjecting itself to possible enforcement? Or just abandoning its investment in those oil and gas leases? These are the hardship choices that the case law says reflect non-choices. There's no good option there. That's why a ruling needs to be made. The ordinances also pose direct hardship on Range by preventing oil and gas development anywhere in the township by excluding the establishment of gas gathering facilities, facilities that are required for oil and gas development to connect a well to market. It prevents Range from producing and marketing natural gas from its already established Connor Samuel wells. That's hardship. Again, what choices would Range be faced with regard to Connor Samuel? Develop plans for gathering facilities that can't be approved under the ordinance because they're exclusionary, because they're not permitted uses, because they can't place those gathering facilities? That's not an option. Develop plans and proceed with construction and then subject itself to possible enforcement or action by the township? That's not a real option. Or abandon its investment in Connor Samuel? That's not an option either. These are all hardships. The township is wrong to suggest that Range needs to do more to establish hardship other than what's already on the record. There's no obligation to apply for a conditional use to develop additional well pads when that conditional use is excluded by application of the setbacks. And then the last argument is a legal argument. And that is that under the doctrine of ripeness, which is a judicially created doctrine, The judges created it. The board doesn't even need to evaluate ripeness because it doesn't apply in the context of an administrative body's review of validity challenge. That's a legal argument that we've submitted in our briefing as well. And then I think finally, the issue of mootness. This is easier. I mean, the other ones were easy too, but this is really easy. The repeal of an ordinance does not necessarily moot any challenges to that ordinance where it has been reenacted in substantially the same form. That's the quote from the Stuckley, Pennsylvania Supreme Court decision in 2013. And the reason for that, the fact that the repeal of an ordinance does not necessarily moot any challenges to that ordinance where it has been reenacted in substantially the same form in another ordinance, is because the underlying controversy remains the same. Put another way, the repeal and reenactment of an ordinance does not moot a challenge to its validity where the amendment does not substantially grant the challenger's relief. In this instance, we had a challenge to the 2024 amendment based on the setbacks. In the 2025 ordinance, those setbacks are still there. They didn't change. There's no definitional changes to the ordinance that modified the substance of Range's challenge. The only thing that was changed was a slight change to the provision of the gas facilities provision, where it allowed for certain uses to be put into an industrial unit. But that doesn't substantially grant Range its relief requested because the ordinances are still exclusionary. And you saw Mr. Limburner's maps. The maps are the same the setbacks are the same under the 2024 ordinance and the 2025 ordinance. And so the fact that there was a repeal of the 2024 ordinance and the reenactment of those same exclusionary zoning ordinances means that it's substantially the same, and under the Pennsylvania appellate precedent, Range's challenge proceeds under the newly enacted ordinance. It's the law of Pennsylvania. There are a couple of cases. This is more directed to Mr. Volz because the argument wasn't addressed on these issues. A couple of cases that were cited in the submission that were not part of the motion to dismiss. And I would like to just briefly provide some rebuttal argument to those cases. Mr. Volz, this is a proposition that was cited by the township in paragraph 201 of their submission that essentially says, while lot lines reflected in the county tax maps generally show the configuration and relative location of tax parcels, they fail to conclusively establish respective property lines from which setbacks in a zoning ordinance are calculated. And for that proposition, they cite the Grace Building Company case, which is a Commonwealth 1983 decision. Just wanted to note, if you read the case, you would see this. That case is not a zoning case. It doesn't stand for the proposition that tax maps are insufficient to map setbacks in a zoning ordinance, as the township states. In that case, the burden was on the plaintiff of demonstrating the actual boundaries of its property, and it relied on the tax map to do so. Here, Range's GIS expert mapped boundaries using generally accepted practices in the GIS industry for mapping of setbacks for regulatory purposes, and there's no evidence that the township itself uses anything different. There was a contention made in paragraph 202 of the submission by the township and the conditional opponents that setbacks in a zoning ordinance are generally measured instead from the terminus of contiguously owned property, not from any internal plat lines within that stretch of property. Township cited 3 non-Pennsylvania cases for this proposition. The first of those cases, the Friends of Ridge cases, relied in part in a Middletown Township case. I'll note that out-of-state cases that set forth a rule don't have application in Pennsylvania. And the Pennsylvania case that was cited to in that Friends case decision is Appeal of Gregor, which is a 1993 Commonwealth Court decision. That deals with the doctrine of merger, Mr. Volz, of estates and land, where the lesser estate is merged into a greater estate whenever both estates meet in the same person. That doctrine has no application, however, to zoning law and the construction of a zoning ordinance here, where the term merger is used to describe the effect of a zoning ordinance on lots held in common ownership and is related to the issue of the physical merging of adjoining lots. In that situation, the burden is placed on the party who asserts a physical merger to establish the landowner's intent to integrate the adjoining lots into one large parcel. In other words, to the extent that the out-of-state law is being considered, it relies on Pennsylvania law that deals with the doctrine of merger. And under the doctrine of the merger, the party who asserts a physical merger, and in this case, the merger presumably is how the setbacks should be mapped. That's the party who asserts the physical merger would be the township here, must establish the landowner's intent to integrate the adjoining lots into one parcel. Since that party who is relying on the merger to advance their argument that Mr. Limburner's maps were not properly applied or the methodology was not proper, it was the obligation of the township to submit that evidence, and there is no evidence. And so I think in general, the out-of-state cases should not be relied upon, but to the extent that they're relied upon because they cite PA cases, the PA case says that the township had a burden that it didn't fulfill. And Mr. Volz, that's all I have. Thank you for your patience, members of the board as well.
Thank you very much. Do you have anything to add to this?
My name is Bernie Matthews. I represent 6 of the landowner clients that have been identified earlier. Ms. Brown's arguments were comprehensive and accurate, so it's unnecessary for me to expand upon them. But I just want to reiterate on behalf of my clients that in my view, this case is not even a close call based upon decades of Pennsylvania zoning law on the issues of standing, ripeness, exclusionary zoning. I think Ms. Brown has exactly explained why the arguments made by the township and those that are joining them simply misstate the law. And I think we adopt those arguments and the factual and legal arguments that Ms. Brown has made. And so I just want to make sure that's clear on the record for my clients. Thank you.
Thank you. Now, Ms. Moore, I'll turn it back to your side for a brief rebuttal, if you would.
Great, thank you, Mr. Volz. And I will try to be brief. There was a lot there. I'm going to be as brief as possible, and I thank you for your patience here. First, I'd just like to state on the record, Mr. Matthews did not have clients who testified here as to any standing and didn't participate in the case in chief, so I'd just like to state that for the record. You know, if we actually had something that we were fighting about, then the issues and the technicalities about the mapping and where you map from and where's the lot line, they would be really interesting questions for you to look at and dig into. But unfortunately, we don't. And that's exactly why they don't have standing and this case isn't ripe. And again, to be clear, you don't pass go if you don't have standing. You don't pass go if the case is not ripe. I'm still asking myself, Range, what are you trying to do in Cecil Township that you currently can't do, not something that's hypothetical, not something that maybe in the future we might run into an issue. What are you trying to do? Because a lot of what I heard over there is them trying to read the ordinance in a way that they're like, man, we're trying to read it so it's unconstitutional. And it's against the clear reading of the ordinance. Case in point, the strained reading of how they believe this ordinance is going to affect any underground pipelines, and not just the well pad. The well pad setback is from the edge of the well pad. It's plain, it's clear. There's a definition for pipelines in the ordinance, but there's nothing that regulates pipelines in the ordinance. So I would ask you just to take a close look at the ordinance as you assess the arguments that they set forth here. I want to be very clear on ripeness. This is not a facial challenge. Okay, I'm not going to spend any more time on talking about the difference, but a facial challenge is when you look at that ordinance and on its face, it is unconstitutional. That is absolutely not what you have here. You have a de facto challenge. You have to look at the ordinance. You have to apply it to something and see if it holds weight. So all the cases cited in the facial challenge portion of their submission, they are all distinguishable, and I would ask you to go through that exercise. I'd certainly ask Solicitor Volz to go through that exercise. I will just at a very high level give you a couple. The Eller case, the Mushroom House case that she started with, there was standing because the applicant was refused to grant additional permits to his house to erect new mushroom houses at his location. The Budco case, where she said, well, you don't need to actually file the application when you do the substantive validity challenge. That was a rezoning of the plaintiff's parcels of land. And in that specific incident, the land was rezoned and the court said, we don't have to submit a specific plan. Additionally, standing and ripeness were not challenged or addressed in that case. The General Battery case that was cited, the plaintiff had standing and the case was ripe because the plaintiff was denied a permit to construct a waste disposal facility at the location, and therefore the issues of standing and ripeness were not even raised in that case. You can go through the exercise. As you go through the exercise, I think you are going to land in the same place, and that is, this is not a facial challenge, and therefore you don't get to avoid the issue of ripeness. And I would point you back again to the Pennico case, where the Commonwealth Court specifically addressed ripeness. When the zoning board addressed it at the first level, the Commonwealth Court addressed it. And in the Pennico case, that ordinance itself specifically said in the language of the ordinance that no underground injection wells are allowed anywhere in the township, period. But the Commonwealth Court still addressed ripeness. That's far from this case. This ordinance doesn't say well pads are prohibited in the township. It lays out a process. There are setbacks. There's a waiver provision. And if you go through the process of applying it, and in the process of applying it, you're actually supposed to apply it to something, right? That's why we have standing and ripeness. You would see that they didn't meet their standard to demonstrate that it was exclusionary. So I'd ask you to take another look at the Pennico case. They rely on the testimony of Ms. Black saying some leases are stranded. Please go back and read Ms. Black's testimony. She was unable to answer any questions about whether they were even thinking about trying to reach those particular parcels, whether they even wanted to, whether they made any attempts to even assess whether it was possible. Just because you have a subsurface lease doesn't mean it makes sense or that you even want to drill to access that particular oil and gas. So please go back and read Ms. Black's testimony. They also mentioned the Connor Samuel pad as being stranded. Let me read you the testimony related to what they said about Connor Samuel being stranded. So they made one statement that it might be stranded in the future. And then I asked specifically, I said, okay, well, tell me, please, you mentioned about being potentially stranded, and I'm reading from page 52 of the second night of the hearing. So I would like to understand how Range Resources is stranded at the Connor Samuel well pad. Answer, I believe I answered a hypothetical question that said if Range's contractors were unable to install those gathering lines, then gas would be stranded. I don't think I made any allusion whether they actually were or not. Again, remember, William Penn Standing hypothetical, maybe in the future, doesn't count. So then I asked, okay, so as you sit here today, Range Resources is not stranded at the Connor Samuel well pad question. Then there were some objections. And again, he answered, I asked, you alluded to answering a hypothetical question. I'm asking you the actual question. As you sit here today, Range Resources is not stranded at the Connor Samuel well pad. Is that accurate? After some objections, the witness said, I guess I would testify it's not accurate to say that it's stranded right now because it's not capable of producing gas at this point. Again, hypothetical, potentials, eventualities, future events, that is not for you to decide. Other than those statements, and that is not enough to meet any burden when they have the burden of proof. That's not enough to meet the burden of proof to demonstrate that there's a real actual case for you. And remember also, Range Resources is not a midstream company. They were asked some questions, again, about Connor Samuel and who's going to be accessing the gas. Question, and this is on page 146 of that second night. Do you believe whether, and I believe you said it is another company actually that constructs and operates the gathering system, is that right? Answer, that's right. Question, it's generally Mark West around here, is that fair? Answer, for a good portion of the field, yes. Question, do you know if that company, if the company that would own and operate the gathering system, has it obtained any approvals from the county for any component of the gathering system? Answer, I don't know the answer to that, sir. Question, do you know whether it's received approvals from any other regulatory agencies for the gathering system? Answer, I don't know. Or any component of the gathering system? Answer, fair enough, I don't know. Question, do you know whether any construction has begun on any components of the gathering system that would serve Connor Samuel? Answer, I'm not aware of any. Question, so then if it has begun, you don't know whether it's continued diligently since it was initiated? Answer, right, I don't know. Question, do you know whether the company, a gathering system company, has committed any resources toward gathering system components? Answer, I don't know. That is not enough to demonstrate standing, and I would ask you not to fall for this. There's a bit of a sleight of hand, I think, that was presented to you, where they said, well, we need standing under the MPC, okay, but not under anything else. Well, it's the MPC stand, and there's two different parts. One is if you're a landowner who's trying to do something on his or her land, and the other is if you're aggrieved by someone else doing something on his or her land. And then they said, well, the aggrieved standard doesn't apply because we're talking about Section 1. Well, the aggrieved word and the standard applies because that is part of the William Penn analysis. They say to demonstrate you have standing, you have to demonstrate that you're aggrieved. And to be aggrieved, it must be substantial and direct and not something that's going to happen in the future. So that's how that all fits together. And as you read these cases, and I know you will, please look at that. It's not even them. If there is some gathering facility, it's not even Range Resources. You don't see the gathering facility. They're not in here challenging the ordinance. So that is something I would ask you to consider as you go through this analysis. Again, I think they spent a lot of time trying to read the ordinance in an unconstitutional way, and that's not how you do it. Typically, you try to read the ordinance in a way that would be unconstitutional. And again, what typically happens is you would have a dispute, you would have some kind of application, and there would be a discussion with the township on, okay, how are we going to apply the ordinance here? How should it be applied? And that is not what happened here. They are trying really hard to read this ordinance to you in a way that they believe is unconstitutional, and it just doesn't fly in this scenario. A couple comments about the Washington County Planning Commission and Mr. Cassiola and some statements that they made. I'm not really going to dignify this with a response. There were statements that were made in May of 2024, 5 iterations before the final ordinance that was ultimately assessed and advertised and passed in November of 2024. Anything one particular supervisor says isn't binding on the board, and any particular supervisor may say anything at any particular time. Again, different ordinance, different time, and you can take those statements with a grain of salt. You are here today to look at this ordinance, how it ultimately ended up after at least 5 iterations and changes and different approaches to how to do this. So I'd ask you again to focus your analysis on this ordinance and frankly, focus it first on their standing and whether this case is ripe or not. I'm not going to dive into the South Point issue again. I think I was very clear in my argument. This isn't South Point. And when you read the cases, you will see why. So I think it will speak for itself, and I think you will then understand the difference and that applying this to South Point does it a disservice because it is not unconstitutional consent zoning by any stretch of the imagination. And instead, what the legislators did here, what the township supervisors did here, was they did make those difficult decisions. They decided, based on health, safety, and welfare, what was an appropriate setback. And then they allowed the waivers, which allows a property owner to make those decisions for him or herself. And that is completely constitutional. So they made the tough decision. They didn't delegate the tough decision. They made the tough decision. I heard Ms. Brown say in her argument that imagine how many waivers would need to be obtained to be able to put a well pad. Well, you don't need to imagine. They could have done the work if they wanted to do it to actually figure out if there's a site where they want to put a well pad and how many waivers they would need. That statement alone demonstrates the hypothetical nature of the question that has been put before you tonight and the reason why the consideration of these questions should end this evening or with your vote respectfully. I'm just going through my notes to say, I don't want to address everything she said, but some of the biggies I want to make sure I have addressed for you. I guess I would ask at this point, if the board has any additional questions based on what Ms. Brown said or based on what I said this evening, we'd be happy, I would be happy to answer them for you. I'm sure other folks on this side of the table would be happy to answer those questions. I don't want to go on ad nauseum. If there are specific burning questions that you have, I'd rather get to those. But first, I'll allow any of my other colleagues if they have anything they want to say.
Thank you. Solicitor Moore is correct that there were many hearings which led to the enactment of these ordinances. The one thing that Range's attorney didn't tell you is that Mr. Cassiola signed both of the ordinances. He voted to approve the ordinances that were signed, notwithstanding what was probably a valuable debate on the merits of various changes. So the board can certainly take notice of the fact that Mr. Cassiola, upon whom Range relies, actually approved the ordinances. My family went to Kennywood today, and I don't like to ride a lot of those rides because I feel like they shift my internal organs. And tonight, when Range began, the fifth thing that Ms. Brown said is that the one thing we can agree on is this is a de facto challenge. And then my organ shifted at the end of her argument when she said, oh, this is now a facial challenge. Well, it's one or the other. And the reason why she made this enormous shift in Range's argument is so that she could tell the board that they didn't have to have, that their challenge did not have to relate to any particular property. Now, let's talk about why that is wrong. So as she said, the fifth thing that she said tonight, because I was taking notes at that time, she said that we all agreed that this is a de facto challenge. And then she read accurately a statement from a case which says that a de facto challenge arises when the ordinance itself, on its face, does not prohibit the use, but it's impossible to achieve in reality or in application. And then they went through 3 nights of hearings with exhibits and testimony telling you not that the ordinance prohibited the use on its face, as now they're saying, so that they can shift their standing position, but rather that, well, it allows oil and gas, but in application, it does not. Well, they're not allowed to make that argument unless they have a particular property to which the ordinance is applying. So that was an unbelievable shift. Now, a facial challenge, which much later in their argument, about an hour and 15 minutes in, they decided they had a facial challenge, that would be an ordinance that says, under our zoning ordinance, you can't have a synagogue, or you can't have a black church. We wouldn't have a 5-minute hearing on that, because you know that under the Constitution, you can't have a zoning ordinances that says you can't have convenience stores or synagogues or something like that. Clearly, it's a facial challenge. You only have to look at the face of the ordinance. But here, they spent 3 hearings not looking at the face of the ordinance because they concede that the use is permitted. This is a de facto challenge because they put on all this testimony saying that, well, as you apply the ordinance, you can see that it's exclusionary. That's their argument. And you're not allowed to do that unless you have a specific site in question. Now, I want to translate some things that Attorney Brown said. She said, well, if you have access roads, they're necessarily going to cross a property line, but they don't have a property line to talk about. So what she's really saying is, members of the Zoning Hearing Board, would you please just imagine what's not in the record? Imagine a site, imagine there's an access road, and imagine that you have to cross property lines. The same things with gathering systems. She's just asking you to make assumptions which are not part of the record, nor were they even attempted to be made part of the record, that you have to cross these property lines. And with regard to the gathering systems, Range did not put in any testimony, any evidence whatsoever, and I don't think they even disagree, that they're not in the gathering business. While they'd like to be the ombudsman for the entire oil and gas industry here in Cecil Township and speak for everybody and say that no one can drill oil and gas in Range in this township, they also want to be the ombudsman for the midstream industry. They're not in the midstream industry. And when you look at what little specific information they had about sites in which they have an interest in Cecil Township by virtue of a lease, they say, well, we've got a lot of leases. If you narrow that down, the only ones that we really are relying upon are those which are potentially stranded. And then when you narrow it down even further, you get down to only 1 paragraph in their entire thick findings of fact and conclusions of law. That's paragraph 64 in their findings of fact. And they talk about the Connor Samuel pad, which says that it's a nonconforming use. The setbacks applicable to gathering facilities present range from transporting natural gas. Not a setback that applies to the business that they're in, which is the drilling of or development of well pads, but in the midstream business. And they're not even in that business, and they don't purport to be in that business. And by the way, maybe they're purporting to get into the business, but put all the pipes on the ground or above the surface. These gathering lines are below the ground, and they're not regulated in the first place. And yet a lot was made of that. And their entire case also relies upon the fact that landowners in Cecil Township would sign leases to develop oil and gas facilities on the surface and then not grant any waivers. That's almost an absurdity. Probably people are going to either allow it to be developed or they're not. If they choose not to sign a lease, they couldn't develop it anyway. Also, we have to watch out for this shift. Attorney Brown spent a lot of time talking about the validity of the waiver provisions. One of the last things that she said was they challenged the setbacks. And now we're not only sneaking in the challenge to an ordinance that was passed after the ordinance that they challenged, but now we're sneaking in a validity challenge to the waiver provisions. They did not challenge the waiver provisions initially. Okay, thank you very much.
Attorneys Moore and Ferguson did a great job of explaining why we don't need to focus on what Range is actually trying to prove here today, because they don't have the procedural standing and the case is not ripe. But I am going to focus on what they need to prove because we spent a lot of time here and it's important. So what Range has to do, Range has the burden of proving that the democratically elected government of Cecil Township was wrong about what it's able to do and isn't able to make this protection for its citizens. So that's their burden to prove that they passed this illegally exclusionary zoning law. To do that, they had Mr. Limburner develop a map. And Mr. Limburner is an expert. He has a lot of experience. It seems like he meant what he said. You are allowed to evaluate what he said on its face. You do not have to accept his conclusions as complete. If he says there's an exclusion here, you do not have to accept that on its face. You have a job, and part of that job is evaluating what Mr. Limburner told you. Mr. Limburner's job was to tell you that this ordinance completely excludes the development of oil and gas in Cecil Township. What he said was that he used emergency service data to prove that there are so many protected structures in the township, and that if you look at all those protected structures and draw that 2,500 foot radius around it, there's nowhere in the township where you can develop oil and gas. What he said in that hearing, when my colleague Mr. Johns asked him, if a residence were to be occupied at one point in time and later vacated, would it still be reflected on the 911 location map? Mr. Limburner said, yes, it would be. Even though there's not a resident there, it would still require emergency services for police, fire, et cetera, et cetera. So even that shapefile would potentially include buildings where no one resided, theoretically. So he didn't say, I'm putting buildings up there that I know aren't occupied, I'm lying to you. Of course he wasn't doing that. He was just trying to say that his job was to say that he knows right now this ordinance is exclusionary. And when he was questioned on his data sources, he said, well, they don't really prove anything. There are structures that could be unoccupied. I don't know. I haven't checked it on the ground. Now, I'm not trying to impugn his process. He had an impossible job to do. Because as Range said, what they're trying to do is show that the ordinance, under no circumstances ever, could be non-exclusionary. What Mr. Limburner was tasked with doing was quickly, with reference to no particular ongoing project, use what data he could to make that case that it was exclusionary. But because Range is trying to show that there's an actual exclusion from the township, but not tying that to any time, not trying to connect that to where people actually live, just trying to use their best approximation of what may be happening now, what may have been true when the 911 data was collected, what may be true at some unidentified time in the future when Range actually builds or tries to build a new well pad, that there is some exclusion here. Mr. Limburner had an impossible job, and he wasn't able to do that. He wasn't able to do it because Range is not trying to do anything, because their case is not ripe, and he wasn't able to do it because it'd be very hard in those circumstances to prove an actual exclusion. Some other things, the property line issue, there's discussion of what property lines means in the ordinance. It's not defined in the ordinance. Our side provided some case law about how in different states and zoning contexts, in other property contexts, property lines has been defined. It's unclear. Mr. Limburner chose one definition. The ordinance does not say what Mr. Limburner says it does. He does not get to decide what the ordinance says. It's up to you all to decide whether the ordinance itself is exclusionary. As far as whether Range has met its burden to prove that the ordinance is exclusionary, they mentioned in this discussion about whether the gas extraction, which is what their business is in Cecil Township, could be achieved with surface structure outside the township. Range said that the township hasn't made any showing that it's possible to access the Cecil Township gas from outside the township borders. That's not the township's burden. Range has come here to say that Cecil Township's Board of Supervisors made a mistake. It is on them to show that they are not able to extract gas from Cecil Township, and they haven't done that. That's all I have. Thank you.
Josh Brown here for Georgetown Estates, and I get the benefit of going last, so I can say I agree with what everybody else said before me. But I agree with with my fellow attorneys on this side of the table that a lot of ranges position is just hide the ball, and that's problematic for us here in Georgetown, where they're trying to say, oh, you don't, as Attorney Ferguson mentioned earlier, you can't have any standing because you're not affected. Well, where are you drilling? Well, nowhere. But a lot of their case really, they really desperately want you to look at the South Point case, and a lot of their brief really circles around that case. But if you look at the South Point case, guess what? They had an application for a site plan approval in that case. So that case was ripe. This case, there's nothing. That's all I have.
Thank you. Ms. Brown?
Mr. Volz, with your permission, I'm going to let Mr. Hughes go first. If that's all right. He's going to address one of the questions, and then I'll finish up with the rest, if that's all right with you.
Oh, absolutely. Mr. Matthews?
So I just wanted to address this issue of de facto facial challenges versus some other type of an applied challenge. In Pennsylvania, there's two types of facial challenges that are made in zoning cases. One is called a de jure facial challenge. It's easy to understand that one. If I look at the ordinance and a lawful use is not allowed in any zoning districts, as a matter of law, de jure, it's been excluded. So you read the ordinance, it's excluded as a matter of law. And those cases historically have been, for example, municipalities will say, well, we don't want adult businesses in our community, so we're not going to allow them in any zoning district. And the courts have said, no, you have to allow adult business in your, because if you don't, they can go anywhere, subject to further regulation. So that's a de jure facial challenge. The other type of facial challenge is a de facto challenge. That's not that you submit an application and you get denied. What a de facto facial challenge says is, look, the ordinance permits the use, but it really is a fake permission because when you apply the regulations, i.e. the setbacks, it can't go anywhere. So it's been de facto, in fact, excluded. Those are your two types of facial challenges in Pennsylvania. The idea that you can never challenge an ordinance unless you come in with an application of some kind and get a permit denied is just simply not the law in Pennsylvania. So I just wanted to try to clear that up for the board, hopefully in simpler terms. Thank you.
Point is that ranges challenge. I'm going to just hang on to it because apparently I have problems with this holder. The point is that ranges challenge is recognized under Pennsylvania law. It's not one or the other. We don't even change positions or arguments about what the type of challenge is. It's a particular type of challenge, as Mr. Matthews described, under Pennsylvania law, and it's well recognized. And so we didn't want you to be confused that somehow by virtue of the different types of aspects of the challenge that there was some kind of, as claimed, switch in range's position. It's not. It's all in the same challenge. Very briefly, I'm not going to go into the arguments about Mr. Limbrunner's report because I anticipated those. Those were submitted in writing, and I've addressed those before. I'm not going to repeat those. I've already addressed those. I'm going to just deal with two issues. One is about Mr. Casiola's statement. The reason why that statement is significant is it's a recognition by the chairman of the Board of Supervisors that even a 1,500-foot setback would be exclusionary in Cecil Township. Not about the details of the ordinance that was before it at the time. It's about the fact that there's a recognition. That recognition is cumulative. It adds to the fact that Mr. Casiola recognized that Cecil Township basically would preclude oil and gas development when you get above 1,500 or slightly above 1,500 feet setbacks. Further proves Range's position that the ordinance setbacks here in the ordinance that we're challenging are exclusionary because they are way longer than the ordinance, the setbacks that Mr. Cassiola was talking about. So that's the reason why it's relevant. The other thing I want to address is really in black and white in the ordinance, and it's the same definition in both ordinances. There's been a suggestion that Range's arguments about gas gathering lines, just like that we somehow made it up, or we don't understand the ordinance, or we're looking really hard to find an exclusion. It's right there in black and white, members of the board. If you look at the definition of oil and gas development, the term is oil and gas development or development. They have the same definition. It's really long. I'm not going to read the whole thing. But it includes the well site preparation, well site construction, drilling, hydraulic fracturing, and or site restoration associated with oil and gas well, an oil and gas well of any depth. And it goes on and on and on. On the next page, it talks about and the site preparation, construction, installation, maintenance, and repair of oil and gas pipelines and associated equipment and other equipment and activities associated with the exploration for, production, and transportation of oil and gas. Exactly what I talked about is being precluded. It goes on. And other natural gas compressor stations and natural gas processing plants or facilities performing the equivalent functions that operate as midstream facilities. Natural gas compressor stations and natural gas processing plants or facilities performing the equivalent functions that operate as midstream facilities are only authorized consistent with the Township of Cecil Development and Land Development and Zoning Ordinances. So the definition itself talks about maintenance, repair, installation, construction of oil and gas pipelines, gas gathering facilities that Mr. Mantico said, pipelines, as well as the transportation of oil and gas. And then when you go to the setback provisions, paragraph 36A, this is one of Range's provisions that are challenged. The title of that provision is Oil and Gas Development Facilities. And it talks about, before it gets to the actual setbacks, it kind of sets up what they're actually applying the setbacks to. And it says, the following requirements shall apply to oil and gas development, that's a defined term we just talked about, facilities which employ the use of compressors, motors, or engines as part of the operations and or produce air contaminant emissions or offensive odors. Subsurface facilities. Remember when you were told that underground piping wasn't regulated? Well, guess what? This ordinance purports to include it. Subsurface facilities, including horizontal drilling facilities, gathering system facilities, and production facilities. So it's right there in black and white. We're not making it up. We're not wishing it was there. It is there in black and white. And that's all I wanted to tell you, just to point out that definition and those sections that relate to the setbacks and how they relate to our arguments. Thank you very much for your time and your patience.
Thank you very much, everybody. I'm going to call an end to the argument. I would like to thank both sides. The issues were well addressed, and I think the board has received the clarification it needs to make this important decision. Moving forward, I believe we are going to do our best to meet for several executive sessions and have a decision by Monday, the 16th. And it could be that we move forward with the township's opportunity to present its case, or it could be, approving one of these motions. So with that, could we have a motion to continue this to the Monday, June 16th hearing date at 7 o'clock? Monday, June 16th at 7 o'clock.
I'll make the motion that we continue this meeting on Monday, the 16th, at 6 o'clock.
I second. All in favor?
Aye.
Mr. Volz, may I ask one clarifying
Absolutely.
question? I think I understood what you meant to say. There will be no, in any circumstances, there will not be a continuation of a hearing with witnesses on Monday.
Correct.
That was my understanding.
Correct. If we will announce our decision on Monday, if we are able to get it done. If we can't make it, we'll let everybody know, but the plan is to work really hard over the weekend and be ready to go Monday night. And correct, if we elect to move forward, there will be no evidence taken Monday evening. I believe when we started this, we would say the township and their side would have 30 days at least to prepare for any upcoming hearings. So with that, could we have a motion to adjourn?
I'll motion that we adjourn.
Second.
Second.
All in favor?
All in favor?
Aye.
Thank you, everybody.
Go to bed.
Yes, ma'am. I am Gilly.
I'd be going to bed.
You know what I'm doing. Why would you call me 5 times in a row?
Right. Right. But it's, and then not, the rest is, you know what I mean? So, yes. Try to read the ordinance.